Okay. People are joining in very quickly. Wow. Let you slow down a bit. Wow, the numbers keep going up very nicely. If only crypto goes up nicely once again. As fast as the numbers I see in the attendees list. Something to wish for.
It did, but it came down quickly.
Now, hopefully it's as stable as this. Yeah, this is very stable number. Coming to 170 folks joining in. Just give me one more minute. I think, well, the numbers are still rising. So, okay, I think more or less stable. Okay, welcome everyone to once again to the BAS webinar. Much overdue. I think the last one was last year. So I think much overdue. We are starting to come another webinar. This time a very, very important webinar. Thank you for joining us. I think this is something close at heart to everybody, right? Be it you being a crypto service provider, be you a trader, right? A user who actually benefited from the crypto economy, or you're someone who actually operates as an influencer or marketer, right? So all these are actually very much impacted into this right now. So I think welcome you to come to today's session. We are coming to the core of the problem with regards to how it impacts everyone in this particular space, as well as clarity. Because I think if you look at the the MES guidelines with regards to advertising for crypto companies, I think it was rather sparse compared to previous announcement and all that. And I believe everybody was pretty shocked and surprised by it as well, right? So it came all of a sudden. So I think there's a lot of queries in your mind, as at the same time understanding how it impacts your business if you're in this space. So I think today's session is really about that. We have a survey done. So I think for some of you who have registered, for this particular session, we have probably received that email in your, the email goes to the survey link. So do take time to actually go through a very short survey, very simple. I think you can complete within 1 minute, right? So do take your time to actually do this, because we are going to compile the results of the survey after a few days. Besides here, obviously you hope that you share with your friends and others who are actually interested in this space, right? To give their thoughts on the survey itself. We're going to compile the results of this survey. We're going to engage with MES, and that particular result of the survey will be shown to MES about, about the impact of the industry, your concerns, etc. So that this is coming directly from the industry, not just from BAS ourselves, right? So, so if you haven't received the link to the survey or you haven't gotten the email somehow, we will actually share that with you at the end of today, or maybe even the chat group. So take note of that. Now, again, today we want to be as interactive as possible with the panel. So feel free to ask your questions on the question and answer session. We'll try our best to actually explain or also go through your question as well. Now, take note, every feedback given today on print, as in like in the chat group or in the Q&A, will be recorded down, right? So we want to compile and rationalize all the feedback from the industry, and then compile together the results of the survey, and then engage MES and show to them this is the feedback and recommendation from the industry. So without further ado, let me introduce you to the panel. First and foremost, you have a very familiar guy, and described as the handsome ex-MES officer, Mr.
Good Lord.
Right, then we have Pei Ying from Linklaters, right? We have Chai Kit from Synopsys, right? We have Ian, whom I think everyone you have seen here, very familiar faces, but they are explaining their field. We have Ian from Merkel Science, and of course, our dear Mr. Asman from Upbeat. Right. So without further ado, let me just hand over to floor to Nizam.
Thank you, Kevin. As always, your colorful introductions. Very good afternoon, everyone. I think we probably have a record attendance. This is probably one of our better attended webinars. And I think it's a function of the importance that people feel about the recently announced MES guidelines on advertising, which unfortunately has quite a not so great impact on the industry, and this impact, whether you're a crypto exchange, you are a token issuer, or you are a DPT service provider. So we have a set of slides that we were going to take you through for the advertising guidelines, which was announced, I think, in a rather surprising fashion fairly recently. So there wasn't a consultation paper, and we can discuss what it means for that not to be a consultation paper. And I think We also want to hear views from you because this is a very important session where we want to get feedback from the industry. As Kevin mentioned, we will prepare a set of written representations to the MES. So the survey is also designed to get that information. But let me just share the screen. So, okay. I hope you guys can see the set of slides. Okay, great. So let's kick off. So the MES guidelines on the provision of DPT services to the public, as I mentioned, took the industry perhaps by surprise. And I think the more important bit is that people reacted quite strongly to the nature of the guidelines. Now, remember the guidelines technically don't have the force of law because that's just how it is under the MES nomenclature, right? So you've got the PSA, the Act, which got the force of law, the regulations, the notices, the guidelines technically don't have the force of law, but we know that obviously MES takes this quite seriously, and judging by the responses of the industry that people are taking this fairly seriously. So let's have a little poll before we dig into the substance of the guidelines. So Kevin, can you run the polls? So just for us to get a sensing of who's in the audience, let us know if you're a DPT service provider, either regulated or exempt under the PSA, you're a financial institution that offers crypto, whether a bank or a fund management company or a broker-dealer, or you're a payment firm, you're interested, you might be thinking of offering crypto, whether you're a token issuer or you're in the DeFi or NFT space. So just, if you could help us with this, and we were going to announce the results very soon. Kevin, I think you're on mute. We can't hear you.
Sorry, so far I think it's running pretty well. I think around close to half mentioned they are DPT service providers, so either regulated or exempt under PSA.
Can we publish the results?
Just a moment. I think it's still going on. I think people are still adding on. Just 5, 4, 3, 2, 1. Okay. Yeah, I can see it right now, right?
Right. So majority, I think, 41% are either regulated or exempt entities. So that's quite significant. So that's great. I think we have the right audience for these webinar. So let's get into this. Oh, sorry, let's just close this.
Okay, close.
Okay, first the scope of the guidelines. So who are impacted and what kind of products are impacted by this kind? Before jumping into the actual content of the guidelines. So the stated rationale by the MES was the higher risk or volatility of crypto trading for the retail public. So the MES said that they have always taken the position that trading of cryptos is not meant for the general public, right? So the applicability would be the PS licensed entities. Clearly, I think most of the people within the crypto space are still going through the application process. Banks or FIs providing DPT services, or payment entities under the transitional exemption, where I think the majority of people in the audience are today. So the scope is on DPT. So that's very important to note. And so technically it doesn't touch NFTs, but I'm going to throw this issue to the panel on their thoughts on what they think about the scope. That it only impacts these PS licensed entities and also on DPT. So just take a step back, right? If the MES regulates a whole spectrum of financial institutions, banks, broker dealers, securities exchanges, financial advisors, trust companies, and the payment firms, right? Did I miss out anything? Now, these guidelines, these advertising guidelines only apply to DPT service providers, whether you're licensed or exempt or you're a bank providing such service. So even under the PSA, if you are a remittance company, you issue e-wallets, you are technically not caught except for the DPT service provider. So that's how specific these guidelines are. So I'm just going to throw the question to the panel, their thoughts on the applicability of these guidelines firstly to DPT service providers under the PSA, and also their thoughts about the other products that are typically associated with cryptos, namely NFTs and DeFi. So who would like to come on first? We have a very quiet panel today.
I'm happy to take the first crack at it. Yeah, so I think firstly, with regards to NFT and DeFi, whether or not it's caught under this, the first question we need to ask is, are they a DPT, right? Because not all NFTs and DeFi will be caught under the DPT definition, but to the extent that they are, then this would apply to it. I think it's also important to take note that, regardless of whether you call something an NFT or a DeFi, you still have to look at the substance of what it is, which means that there's also a possibility that, these assets could be deemed a security, in which case they would then be caught under the securities law. I think what's interesting to note about these guidelines is, I think the intention from MAS is clearly to guard against the risk of crypto to retail. But if you look at the market today, a lot of the retail interest is in NFTs and DeFi, right? So I think, if these guidelines is specifically only for DPT, it may miss the intent, because then it doesn't cover, the NFTs and DeFi, which is what a lot of retailers are interested in today. Yeah.
Chaikit, your thoughts on this? Do you think that NFTs should be within the same bucket?
Well, I agree with what Ian said. I think what's important is that where there is a lot of hype, where there's money, and that's where the public flocks to, right? So and as we all know, I think the areas of whether before we consider whether the guidelines should apply to NFT, we need to obviously consider whether, number one, is NFT or should parts of NFT be regulated in the first place, right? Unless it is a DPT or a securities token or investment purposes, otherwise it wouldn't be caught under the current, legislation of PSA or SFA, for example. Then you consider whether if it's not caught, then technically speaking, the guideline obviously doesn't apply to them. But it's kind of an unintended consequence, because if it's the public, in my view, generally cannot make a distinction between NFT versus crypto, right? It's all in the same bucket in a very simple mind of the general public. So by doing this, to say that if it's only for DPT service providers that are licensed or exempt or under the transition exemption, then there is unintended consequence of excluding a category of participants that, quite likely that should be what MAS would want to limit in terms of the misrepresentation or the over exaggeration of the underlying services that they will promote or they will advertise. So that's the key part, which will then end up in a situation whereby things that should be curtailed are not curtailed, and things that are people who are trying to do the right thing by getting the license and exemptions, got kind of a slap, and their marketing effort or trying to run the business in a legitimate manner, is hampered.
Yeah, I would agree with Chaikit and Ian. One interesting thing I note is that in the UK, and we'll talk about the UK regime in a later part of the session, but in the UK, the rules are being released for consultation, not a complete ban. So interestingly, NFTs are on the face of it also carved out. So one possible reason could be that the regulators has decided to take a proportionate approach. So you start first with DPTs and potentially, extend it to other types of cryptocurrencies in the future. Although I fully agree with what Ian and Chaikit said, that the retail person out there in the general public may not be able to make that distinction.
Thanks. Thank you, Pei, Chaikit, and Ian. I'd like to move to one of the questions. The questions are coming in fast and furious, and that's great. So keep them coming up. One relates to the nature of the fact that these are issued in guidelines form, and the question is this: that if the DPT service provider breaches the guidelines, is the issue that there's a breach of PS NO8, which is a notice under the Act, which has got the force of law, or is it a fit and proper issue given that the MAS takes the view that DPTs are not suitable for retail? So anybody wants to jump on this? Peng, you want to take a crack at this? I think it's a legal question.
Yep, happy to. So breach of guidelines, technically not a breach of law, not a criminal offense. It would affect, as as the question rightly pointed out, fitness and properness of the applicant involved and its key officers. And also for applicants of the DPT license, we understand that the MAS has also sent a circular to all the applicants and the licensed persons to say that, you need to stop immediately, and otherwise we would consider this in your application in deciding whether or not to approve your application. And also, if you are licensed and going forward in any kind of inspection in the risk rating of the DPT firm, any such breach would be taken into account. Okay,
there's a follow-up question. So if the guidelines do not apply, does it mean that people will still be able to advertise? So for instance, a DAO can advertise to sell their BAYC blatantly without any consequence. On another extreme example, this really doesn't make sense to me. And precisely the guys trying to follow the regs are punished. Strange. So any comments from the panel members on this? Can you still continue though? Yeah.
Well, I think in Singapore, generally speaking, or maybe based on historical experiences, when MAS issues a guideline, people or the industry generally follows as much as possible, right? Now, there are obviously ways, because it's so brief, because it's only like, what, 1.5 or 2 pages long, and it's kind of brief, and one of the things that we're going to talk about is whether MAS, should issue a more fulsome FAQ to supplement the guidelines so that people can actually implement it in a right frame of mind. Now, so with that as the background, it will mean that whether you are currently being licensed by the MAS or you are seeking a license, or even you're not licensed, say for example, if NFT for that matter is not a DPT, and therefore technically this doesn't apply to that entity, and that business goes out there and take out all sorts of advertisements on buses, on social media and whatnot. Now, can MAS do anything to them? The answer is probably no under the current scenario. But would there be any other government agency that could actually come in, like I don't know, IMDA or the consumer sector or something along those lines to actually put some restrictions? It could be possible. So, and that would obviously, from MAS perspective, I think it will, not that they will earmark these people, but I think they will probably take into consideration subsequently if these names pops up as a applicant of a license that they are issuing, maybe that will be taken into consideration.
Yeah, I think you meant case. So I mean, I know we haven't discussed this, but that sort of prompt another response, which is that remember that there is a thing called the Consumer Protection Fair Trading Act that specifically talks about false or misleading advertising. There's also a cooling off period. I think, that what you mentioned sort of trigger off that point, and maybe that can be more appropriately considered under the consumer protection watchdog rather than financial services. For instruments like NFT and all that is still very nascent and is still very unclear, I think someone or some agency needs to follow up. Yeah, I think
at least there must be a consistent application across the board, because at the end of the day, like I said, the consumer, the sector or the general retail public can't tell the difference.
Okay, let's move on to the next slide. I think there are lots of questions already jumping into the meat of the guidelines. So, okay, we can take you through what we think the guidelines say, or what the impact or the implications will be for the industry. However, bear in mind that I think one of the points that we are raising, or we will be discussing today, is that there seems to be a lack of clarity on how these guidelines apply in certain scenarios. So we'll also take you through the scenario. So we might not have the answers to all your questions today, but we might think that there could be an issue that maybe a set of FAQs or a more considered or more detailed guidelines could address. Okay, so just bear that in mind. But let me jump to the next. So this is going to the content of the guidelines proper. So these are the prohibited activities. Okay, these are important. So let's go through them. First, and this seems to be the key issue that the MAS seems to be upset with, which is not to portray trading that trivializes the high risk of DPT trading, right? Okay, again, this is very specific to cryptocurrencies. Remember, there are no, there are some guidelines under the capital market side in relation to investment products. But there is, when it comes to no advertising, this is very specific to DPT service providers. So no advertising, not to promote DPT services in public areas or through the media directed at the general public, including advertisements or placing promotional materials in public areas such as public transport venues, broadcast media, periodical publications, including pop-ups on social media, third-party websites, social media platforms, public events, or roadshows. Those are prohibited, right? No advertising. You can't engage third parties, whether social media influencers or third-party websites. This includes joint promotional campaigns to solicit new customers, even if non-product specific. So this is very wide. So even if you don't talk about a particular product or particular cryptos, if it's a promotional campaign to promote yourself as a DPT service provider, you can't do that. And no ATMs in public areas. Okay, there's quite a bit here. So, I'm going to throw this to the panel members on your thoughts on the width of the prohibited activities. So who'd like to kick off first? Azman, your perspective as a crypto exchange.
Yeah, thanks, Nizam. I think from our perspective, we see this as, we expect some sort of a regulation to be coming, personally, in terms of we've been talking about it because we've seen a lot of news report about scams and trading and in terms of the fear in the market. So we expect some sort of a regulation to take place, but I think the manner in which it came about was taken all of us by surprise. Not to mention the lack of clarity. I think that's probably what it boils down to. I can appreciate the fact that MAS do not want to be too prescriptive, but by having it so general, I think it touches upon areas or activities that are not intended to be part of this whole guidelines. And one of them, basically we were discussing earlier on about the ATMs, right? In terms of what is it exactly is it trying to do? In terms of, is it trying to promote DPT trading by having it through making it available to ATMs? That in itself is questionable. When you talk about prohibiting against DPT trading, does it limit to buying and selling to or merchants accepting DPTs as well? So there's a whole host of questions that will fall out of this, whether it applies directly or indirectly to the promotion of DPT trading. And these are areas I think that through this whole event that we wish to get some sort of feedback to MAS to give them better clarity into what they actually intend by having these activities prohibited.
Thanks, Osman. I think we can't discuss these advertising guidelines without reference to the other, the other products regulated by the MAS. So I think that as a consolidated financial services regulator, there should be some harmonized approach when you deal with issues like advertising on risky investment products. So remember, it's not just cryptos which are risky, right? Within the capital market sphere, there are very risky products like leverage FX, for instance, contract for differences with various forms of underlyings or some other derivative instruments. But there are no advertising bans for those products. The advertising ban is only for cryptos. There are some prescriptions on how you were to conduct business as a licensed capital market services provider. So even when you deal with very risky product like specified investment products. Chaikit, your thoughts on the extent to which harmonization should take place. And again, back to the fundamental question, should there be an advertising ban for the crypto guys?
I think as with all regulatory evolution or the evolutions of regulations that the first iteration and subsequent iterations years after takes a while. Yeah. So yes, I agree with what you said, Nizam. I think there needs to be a harmonization, but bear in mind that when PSA came about and MAS brought in the DPT side of things under the whole bit and merged two other legislation together. Now that itself, if I'm not wrong, they made it quite clear that they were at that point in time, which is quite recent, that they were more focused around AML, KYC requirements, CTF, counter-terrorism financing, anti-money laundering, and know your customer. Now, I think, if I'm not wrong, again, Pei can chip in, PSA is in itself has no ambit or no framework that talks about investor protection. Neither does it cover any form of like market misconduct, like the Securities Futures Act, on trading and so on and so forth, right? So none of that exists today. Now, perhaps this was more like, okay, if there's a lot of hype and craze in the market today, we need to do something to kind of knee-jerk and stop certain bad behavior from becoming worse. Ideally, I think what they should have done is that there must be investor protection should actually be embedded, because in order to have that, you need to then define the different classes of investors, like the likes of accredited investors, institutional, as well as expert, then stripped out retail. And at the moment, even in SFA or in Financial Advisors Act, there is distinction on that, and there's exemption. If you're marketing to or writing a financial advice to accredited investors, there's certain marketing or restrictions or disclosure requirements doesn't apply to you. So in order to do that, there's a fair bit of work in terms of legislative change that needs to occur. And I think that will happen in due course, right? So before they do all that, they cannot anyhow prescribe something as exempt investment product, or they have to come up with a new term, because this is not investment product, right? This is not investment product in that sense, so they can't use a similar term. But I would point out that I think the ATM bit is something that, in personal view, it's a bit uncalled for, because when I read some of the news article that came out after the announcement came through, recently, I think it was stated that there are less than 10 ATMs in Singapore. And how is it possible that 10 ATMs actually have such major impact on that side of promoting crypto trading and the ease of trading? Because there's only 10 in the whole of Singapore, and we probably have like thousands of bonds in Singapore. Just one tiny little ATM is sitting in the corner of B1 beside the supermarket. It's not shouldn't really cause so much concern for it to be, for a ban to be warranted. That's my view.
Thanks, Chakit. I think that there's a more fundamental point that you're probably alluding to, and that is the absence of consultation. And the consultation would have actually, I think a good consultation paper should actually do an impact assessment of any new regulations. I think this is one of the points that was made by somebody from the audience. I think some other regulators actually do that. That they assess the impact of new regulations. First of all, the rationale for the need of that, and that has to study the current state of the market and what problem you're really trying to solve, and then the impact, or what they think would be the impact, whether unintended or otherwise, of the new regulations. But in any case, a consultation process would have teased out some of those issues, right? And I think that's the unfortunate thing, because ATMs are meant to be machines accessible by the public. If you put it in an office space, then why is there a need for an ATM, right? You can have somebody there to buy and sell crypto. So it's sort of not understanding the purpose of the ATM.
Yeah, remember years ago when there was a lot of IPO craze, in order to make it easier for people to apply for IPOs, ATM was used so that it makes it easier for people to access, and unfortunately a large chunk of people lost money as a result. So what do we do with that?
Yeah, I do agree. I mean, the two things that kind of struck me was, is there an extraterritorial effect to this ban? Because, the reference to, for example, you're not supposed to use social media platforms seems quite wide. Even in the traditional financial services world, whenever you look at whether a platform would trigger Singapore financial services regulation, you would always look to the Singapore nexus. So you may look at, is there a drop-down menu saying that Singapore is one of the jurisdictions where you can access the platform? Is it in Singapore dollars? Is there a reference to Singapore on the website? So there is usually a nexus. But I suppose here, it seems a bit unclear that, for example, if you use a social media platform like Instagram that's widely used in Singapore, does that alone constitute advertisement to the general public? So that's one. And I suppose the other thing that struck me also was that actually last year in the UK, the advertising watchdog, the regulator looks after advertisements in the UK, they actually went out and issued multiple bans. But their approach was to ban specific crypto advertisements. For example, I think they banned a particular advertisement which said that, well, it's time to buy Bitcoin. They said that was irresponsible. And then there was another one that said, there's no point in keeping your money in the bank. And then there was a testimonial that said Bitcoin was digital gold. So again, that was banned as well. So I suppose it may be that the MAS has been looking elsewhere and had observed this sort of ban. But that, again, was very targeted. It wasn't really a blanket ban. So I would agree that perhaps a consultation may be useful.
Great. I think we're getting lots of questions, and that's really fantastic because we like the interactivity. One of the questions I think linked to what Pei Ying has just said has asked if if a DPT service providers want to target the retail, is there anything that prevents it from advertising globally? So with a disclaimer that it's directed at the general public, it's not directed at the general public in Singapore, and then accepting customers on a reverse solicitation basis. So can that be done? Pei Ying, do you want to follow on from that?
Yeah, well, I was going to say that sounds quite cute, right? Because you started off by saying you want to target.
Pei Ying is going to give some free legal advice, Pei Ying.
Yeah, it sounds a bit cute. I think the MAS will find that.
Okay, there are other, I think very important related questions as well. So for instance, do research reports on cryptos fall within the scope of periodical publications under the guidelines? That's one. And then if influencers have referral links which they promote, would that count? Does it mean that DPT service providers will need to remove all referrals and affiliate programs? So let's deal with those two first. Any thoughts by the panel? Now, again, we don't promise to know what the intent of the guidelines is, but let's just take a crack. Anybody wants to comment on those two bits first? Research reports on cryptos.
In my, I draw a parallel, right? Because research report, if you look at what for the current specific limb will be under the Financial Advisors Act, and as it is, whether you are researching on a particular stock or particular capital market product, there's certain guidelines around what constitute that research, as well as what disclaimer needs to be there and who it applies to, like I mentioned, all those stuff, and who it can be distributed to. If you are writing a research report on, say, Bitcoin, and ultimately, if there are other advertisement banners or whatever that's in between your article, then I think those will become slightly problematic. But if it is on the literature of technical write-up on an instrument, whether it's a currency or a cryptocurrency, fiat currency or cryptocurrency, then I don't believe that itself would constitute will fall under this advertisement thing. It's really advertising. It's not the production of something. It's what you do with it that you send to whoever and where you put it up, right? And who is circulating this for you and what on top of that comes along with it. Now, so in general, as a educational article, maybe it will not be caught, right? But if you promote it in a certain way, then yes, it may fall into the gray area. Now, the other question around referral is one of those things that we were talking about earlier on. Is I think even in the capital market side, the broker dealer side, where I think a lot of brokers are also doing that promotion, right? customer, if you refer a new customer, then you get certain things, then would that be caught under the DPT side? If you have got an existing book of clients, retail, and then you ask those retail clients to say, hey, if you refer to me to your friends, then you get like, a fraction of a Bitcoin, credited to you. My thought on that is that it is probably not covered.
Then yeah, you see the thing about the under the DPT, right? It's clearly stated that any broker of any transaction of a sale of a cryptocurrency, as in like digital payment token, right? The broker, despite the fact doesn't like transact directly financially, but introduced between a buyer and a seller, is actually supposed to have a license or supposed to be regulated. Now, in this case, the influencers and whoever is actually doing this facilitation, despite the fact being affiliates and all that, right? So if you actually use that particular set of rules to actually look at it, then they are supposed to be licensed, they are supposed to be regulated as well, right, as a facilitator. So in this case, right, then that covers them.
No, of course, if you bring in a third-party person, influencer, where the reason why influencer is used for any other purpose, whether is it a capital market product or a crypto product, is for the purpose of using their influence to get the advertisement out there, right, to their network of fan club or whatever, and so that obviously will be I think will be caught under the cannot engage a third party thing, right? But what I'm trying to say is that if you are doing a customer bring customer referral program, then I think those will not be that technically may not be caught. Again, I'm just giving my views lah.
Sorry, if I may raise a point as well, in terms of if the objective of this is to make sure that the retail public who is not aware of the risks are protected, then shouldn't it be that the industry educates the public themselves to let them know of the risks? So in that sense, any sort of publication or media reports regarding cryptos and the trading, shouldn't that be viewed as something that's positive and not be caught under the scope? I mean, this is something that some of the question that I wondered, because I mean, it seems like a bit of a catch-22 that MAS is put forward by this blanket ban on crypto trading. Because on the one hand, you are trying to mitigate the risks and prevent and protect the retail investors from trading. But at the same time, you are not allowing, matters like education on things about the crypto themselves being published. So at the end of the day, you are, the retail public remains in the dark. And I think that's not really quite the intention as well.
Well, we don't know what the policy intent is on educational materials, and I think that's one of the points that's worth clarifying. But I think your points are well taken, Azman, that if the issue is, fundamentally you want a set of investors that are well informed, yes, that are able to make their own decisions. That you don't want them to be spoon-fed. In fact, that is a philosophical approach the MAS took in the early 2000s. When they embarked on a disclosure-based regime.
Yeah, so, even in Europe as well. I mean, they took the informed decision approach, and whereby everybody's supposed to highlight and make it transparent about the risks and everything else. And I thought that, rather than putting forward a blanket ban, I think that approach would have been more savory and more palatable, to the industry, rather than the approach they currently take.
Agree. Yeah, just to finish off my earlier point, right? So in that disclosure-based regime, the role of the regulator shifted from one which, maybe in the 1990s, that only good investment products or retail safe investment products would go to the market. So in the early 2000s, the MAS took an approach that the role of the regulator is not to filter investment products from going out into the market, but the role is to ensure that proper disclosures are being made on investment products. So investors then make their own decisions. So it's a bit of caveat emptor. You decide whether something is good for you or not. Now, along the way, just to recalibrate as well and taking a bigger picture, for investment products that are deemed to be specified investment products, so these are the higher risk investment products, there are requirements, for instance, that there is a customer knowledge assessment. So you don't ban it, but before you sell it, first of all, you need to make sure that it's suitable for your target audience, but there's also a customer knowledge assessment where a series of questions are being asked online to ascertain if the customers in fact understands the risks of dealing in that particular investment product. So only if the guy passes the customer knowledge assessment, then he can buy those investment products. So that's the philosophy. You don't have a blanket ban on advertising. You don't.
Yeah, I fully agree with you, Nizam, and I think that's the point that also that I'm taking, and it underscores the harmonization issue that you talk about. Before we can harmonize with all and everything else, I think they also need to put in place things like retail investor protection in the PSA. I mean, to what extent that product suitability, for instance, are these products suitable for the retail? I mean, is there some sort of knowledge that the investor must display before they can buy or can have access to those products? So these are, I think, issues and matters that haven't been, discussed or even put forward. And I think it's incumbent upon us to bring it out and give it back to MAS to think about.
Okay, there are some other questions. So let's see whether the panel can offer their thoughts on this. One is that, can a DPT service provider advertise to retail their unregulated service, like some DPT earn products? I'm not sure about these products, but can they do that? But I think the guidelines actually say that even if you don't, there are non-specific product-specific advertising or promotions that's not allowed. So what do the panel members think about this?
I think clearly it's very strict. Clearly because obviously, without advertising or promotion, the fact that you are selling that service, then it becomes very difficult for us to be out there and be made known, and clearly will have a significant impact upon our bottom line. And I think this is where some of the clarities may need to be addressed, because they say that you are allowed to obviously promote or advertise on your own website, but how do you draw the traffic to your website? I know that there are certain strategies through Google and all that kind of analytics to be able to, position your website in the first page. But if everybody is just going to rely upon that, then we're going to have a problem with the traffic, in the marketing traffic and the flow of the digital marketing itself. So I think these are definitely some of the areas whereby I think we would obviously like to see more clarity on terms of to what extent that we are allowed to, at least position ourselves in the market space. Because otherwise we have to talk about issues about jurisdiction as well. I think perhaps Pei Ying mentioned about, the scope and the ambit of this guideline. Does it only relate to Singapore? Does it extend overseas? Because we as Upbit have obviously a brand name outside. What if our associate in Thailand or in Indonesia or even Korea were to to market it? Will we be somehow be impacted? Because obviously it applies to the name Upbit. And these are questions that I have no answer to, given the lack of clarity in the current guidelines.
Okay, just to move on some of the other questions, I think one was a question that is on ATMs. So what is it about ATMs that actually raises the issue? Because could a DPT service provider not have an office where people could walk in and trade cryptos on the service provider's computers? Isn't that another form of ATMs? So thoughts on the panel members on this. Ian, you want to take this?
Yeah, so ATMs definitely pose a real risk. From a money laundering perspective, and that's where my area of expertise is, ATMs have been a focus point by the MAS and the Singapore Police, because a lot of victims today, when they get scammed, they get directed to use these ATMs as a way to then transmit the funds to the criminals. But I think in the context of this guideline, right, the intent for the ATM is rather, MAS is of the view that, and again, it's my opinion, MAS is of the view that, they allow ATM to be placed in, public areas, then it may signal to the general public that, hey, cryptocurrencies are a safe, asset that anybody should be able to purchase easily, right? And so, lowering the impression of the riskiness in the eyes of the public. And I think that's really MAS's intent in wanting to remove it from the public space. And I want to separate this again from, my personal thought of ATMs and the AML risk, but yeah.
Yeah, I'd like to differ a little bit, sorry, Ian, but given the fact that I think we need to understand that, if the numbers are correct, there are only 10 ATMs in the whole of Singapore, right? So, and it didn't say that it's completely banned through and through. It cannot even appear anywhere. You can appear in the DPT service provider's office. You can put a, don't have to go to the computer machine. You can actually set those machines that has been, wheeled away. You can actually put it, you can rent a shop and then put it within your shop. You just don't put it within the mall, right? That sounds like it will comply with the requirement.
I absolutely agree with you. I think the actual impact, considering the number of ATMs in Singapore, doesn't yet warrant it. But maybe this, and again, my opinion could be they just want to be a little bit more forward-looking, because they want to avoid having 50, 100 ATMs starting to be deployed, and then they have to wind back and say, everybody, please keep it, right? I think that would also cause a worse impact for the actual businesses deploying these ATMs.
But I think the point about ATMs is not so much a fraud issue, right? It's more a promotion of a risky investment, which is a quite different proposition, because fraud on ATMs also occur on fiat transactions, right? And with the recent phishing scam occurs through SMS and also internet banking. So it's a separate proposition altogether, I think.
My take of ATM is the fact that it has a higher risk threshold, given the fact of the lower KYC involved before you transact into and buying into Bitcoin. And I think a lot of the blockchain monitoring companies have always placed ATM to be at a higher risk category. And perhaps MAS probably by banning or taking out ATM is obviously trying to do away with that risk. Obviously there's nobody verifying your public documents your identity documents or your passport that's received, and things can be done almost instantaneously. So in that sense, perhaps from the regulator's perspective, this may be deemed and perceived as a higher risk to BTC and trading, and maybe something that they want to exclude, and not so much a question of fraud as well. I agree with that.
But again, there's a separate issue, Azman, because if the issue is no KYC, then they can be.
I agree with you. They seem to bundle everything into one ban. Yeah. No, I agree with that. I mean, a lot of the unintended consequences have arisen out of this blanket ban, and I think we are left, floundering to question in terms of what exactly is the objective of this. I'm still trying to understand. Is it really to prevent a ban on DPT trading by retail? Obviously, they say it's not. But then, if that's the case, shouldn't you be educating the public rather than banning the marketing or the promotion of it? So I mean, I'm left with this type of question, and I don't think any one of us are in a position to answer. And that's why I think we need to provide this real feedback to MAS. Hopefully, in that they can consult and look into it more clearly and give better clarity as to what they really intend by these guidelines.
Okay, let's move on to the next slides. I think there are some more questions. We'll jump to that in a while. I think the questions are coming in fast and furious, which is good. Okay, here is quite a peculiar approach. So the guidelines address the issue of payment token derivatives. So these are derivatives that make references to a cryptocurrency. They could be a CFD or future. So they could be a CFD on Bitcoin, Bitcoin futures, or somebody creates an index that references, let's say, to a bucket of cryptocurrencies, right? So these are derivatives. Now, remember a bit of a recap. MAS issued a consultation paper sometime back, I think more than a year ago, that says that they don't regulate payment token derivatives, PTDs, except for the approved exchanges. And in Singapore, there are only 4 approved exchanges, right? The 2 SGX exchanges, Apex, and sorry, what's the other one? ICE. So these are the approved securities exchanges under the Securities and Futures Act. So for them, derivatives are regulated, but for all the other entities, these are not regulated, right? We don't have to go into the rationale for that right now. Now, for PTDs, the MAS's concern is that you cannot mislead the public to say that these derivatives are less risky than trading in cryptocurrencies. And I think that's probably a fair point. And PTDs can only be offered by the legal entity which is not regulated under the PSA. So now this is I think it's new, because it's saying that if you are licensed, or presumably if you are an exempt entity under the PSA, you can't offer derivatives. So this is again, this could be a new requirement, except for the SFA or the FFA licensed entities. But technically, it can be offered by another entity, right? That there could be a sister company of the crypto exchange, for instance. But the curious thing is that I think technically you can still make an advertising or advertisement on crypto derivatives. So that seems to be not prohibited. So any thoughts by the panel members on this? Chaikit?
My quick sense is that it's it's very awkward, as you pointed out, and I think, going back to my earlier point, I don't think the retail public or the general public can make a distinction about all these technical terms, whether it's caught or it is not caught. If people make the assumption, at least within Singapore, if things are being done in Singapore, it must be legitimate in general, okay? And so if there is this ability to advertise payment token derivatives via an unregulated entity, I think, in fact, as we said earlier on, I think that PTD itself is riskier than the underlying payment token on its own, right? Then you are not really addressing the actual rationale of why you want to have this restriction on advertisement. If there is a carved out to say that if you offer it outside of a regulated entity, then it seems to be okay. But remember, don't mislead. What does that actually mean for people? Because there's no clarity around what amounts to misleading, at least under this this guideline. So it all points back to the need to have a much more fulsome FAQ of sort that sets out the regulatory intent of this, I think. Every product has risk, right? Like one of those comment mentioned in the chat. But I think the key point here is that there's also a need to, technically there's a distinction between, I think there's a lot of people trying to, ourselves as well, to bring in the parallel comparison with capital market product, investment product. And, strictly speaking, a DPT is not investment product per se, it's meant to be payment, but just like NFT and all token, any instrument that have got a possibility, or people can have the possibility of making money, or speculate in it. Nobody really cares whether is it a payment or is it an investment, because most of the time, I believe, where people are at the moment into any of these instruments, I call them instruments, not investment product, it's all for the purpose of speculation. 90% is my guess.
Yeah, I would
so
agree.
if you have different, if you have different treatment just because of technical definitional differences, then you're not going to make the general public wiser. And I would totally agree with Azman's point on education. Now, education needs to not come from the regulator alone. It needs to come from the industry. It needs to come from the service provider, or the consultants, or even DPT players, right? With a pure intention to educate. But as we are in business, nobody does free education. We're not running schools here, right? Then maybe the educational side we can engage with via Blockchain Association of Singapore, with the tertiary institutions, to promote that education side of things. Sorry, Ping.
Very good points raised by Chaikit that I agree with. I was just going to add that, this does create a bit of a curious situation, and we have already started receiving some questions from firms about, well, is there a way to restructure my product so it's not a DPT and it becomes a DPT derivative? And depending on what the product is and what it wants to achieve, there could be ways to do that. And this may result in unintended consequences, because are you effectively resulting in the fact that you're encouraging riskier trading? So that's a question mark. I suppose the second thing that came to mind was that the rationale for not regulating payment token derivatives was really the MAS's observation that the volume of trading in Singapore remains low in their view. So they did say that things could change. So perhaps if more and more retail investors are going to invest in payment token derivatives, then the ban could extend to those derivatives as well.
Yep. Yeah, great points, and there could be unintended consequences of this approach. Let's move on to the next slide. And now let's talk about what's permitted, right? So we've talked about what you can't do: no advertising in public places, no ATM in public places, no use of third-party websites or social influencers. Now, this is what you can do. So it's not a complete ban on any form of advertising. So you can self-advertise on your own website, okay? You can advertise on your mobile apps or your official social media, but you cannot trivialize the risk of trading in DPT. So that still remains. So it's no third-party advertising, you can do it yourself, but it begs the question, if you're a new entrant, how do you then acquire new customers? Because you can't rely on any form of advertising in effect, any form of third-party advertising actually. So remember, the point is that this again is only specific to crypto entities or exchanges or intermediaries, but no other forms of financial institutions are subject to these restrictions. So turning to the panel, your thoughts on this. Azman, I think you're probably amongst us the most affected by this.
Yeah, I think it's a little bit harsh on us. I think given in the context of the fact that we've discussed all of this unintended consequences, whether or not, first of all, the scope and the ambit of these guidelines, whether it should cover everything and whether it should cover, I mean, it seems to be clear that it allows self-promotion, but again, what if something was done outside of Singapore, and obviously with cross-border, online treatment, you would definitely be able to access it here in Singapore as well. So, I mean, in some sense, it becomes, a big question mark to us in terms of to what extent are we allowed to be able to promote ourselves, I mean, within your own website or within your own country or within your own organization, if you have your other affiliates and sister company outside of Singapore. So that's one area. Another area that I would like to highlight is the fact that, I mean, this is a recent example whereby, we were trying to contact with some media regarding a press release on the travel rule solution, which clearly is outside the scope of DPT trading. And yet the media company seems to take the approach that, this guideline seems to also apply to that. I mean, it took a lot of argument before we were able to pursue it. But nevertheless, I'm sure there has been a lot of other intended consequences, again, the use of it. And I think that seems to be the buzzword today, that I think we need to get a lot of clarity from MAS in terms of what is it exactly they are trying to achieve by putting forward this blanket ban. But what is clear to us is that I think we need to have a further explanation or distinction in terms of carving out some of those areas that they do not intend to prohibit or to ban. So I think that's clear from our perspective, that we want to see at least MAS being clear what is it exactly that we can and cannot do, rather than just the current language which we think is still not clear enough.
Thanks. Any other thoughts by any of the panel members on this? Well, sorry, does anybody want to say something?
I was just going to add a quick point. So I do think that it does raise some practical considerations around what type of advertisements may be permissible. So to raise an example, in the UK, there was actually a complaint to the advertising regulator about this ad for a crypto exchange. And apparently the ad had a very long disclaimer, but the regulator there considered that consumers wouldn't have had time to understand all the information in that disclaimer. And so it was not clear. So I guess there's also a question around what type of advertisements and content would actually satisfy the standard required.
Thanks for that. Okay, there is a question on activities which are not regulated, right? So that's activities like providing custodial services, or somebody promoting or transferring cryptos, for instance. The question is whether this applies to those activities. Any of the panel members want to provide a view on that? Paying, do you want to take this? The question is whether it affects non-regulated activities for now, like custody.
Right. Well, because custody is not currently regulated, so it wouldn't be regarded as a DPT service. But of course, that is going to change very soon. It's not known when exactly, perhaps sometime this year, when the Payment Services Amendment Act will take effect, and then it will be quite wide. So it will cover custody, where you facilitate the transfer of DPTs, or even if you are a broker or somehow inducing somebody to buy DPTs. So it would be broadened in the future.
Thanks for that. Let's move on. I know the questions are coming. We'll get to them in a bit, but I think it's important for us to talk about our sense of the implications. I think some of these are actually they seem to echo some of the comments that we see in both the Q&A box and the chat box. I think one is that it could confuse Singapore's positioning as a fintech or a blockchain hub. So remember, MD of MAS, Ravi Menon, he made a speech at the last FinTech Festival in November about how Singapore seems to be embracing blockchain, crypto, CBDCs, and DeFi. Yes, in the speech, he said that cryptos are not meant for retail, but the general sentiment seems to be that these guidelines, which obviously impact the broader ecosystem, seems to be regressive, right? Remember, Sobnendu Mohanty actually made these comments previously that there used to be this false narrative that you can separate blockchain from cryptos. Well, technically you can, but he said you can't because the use case seems to be intertwined, right? So you can't really say that cryptos are bad, blockchain is good. That doesn't make sense. Now, the important bit is lack of consultation. And I think there's quite a few comments on this as well. So we firmly believe that consultation are important because they address unintended consequences, right? And I think it's a very important process where the regulators must take into account feedback from the industry so that you can come up with sensible and risk-focused regulations and progressive regulations, which is what Singapore is supposed to stand for. And then the other sentiment is that I think, okay, is it too blunt to state that crypto is not meant for the general public? Probably, because there are communities which are familiar with higher risk products. The sentiment is that a complete third-party advertising ban is a blunt instrument. And I think the other point is that it might create a negative perception of the industry. Already, it's a battle that industry players are already going through over the many years. So there's already anecdotal cases about landlords not willing to rent out premises to crypto firms. There's talk about a blanket ban by the mass media. So all these might not be great for the industry. So I'm going to pause here. What do the panel members think, and any other thoughts on the implications?
I agree about the downstream impact, and what you mentioned about the public already having a negative perception about crypto. This is especially true, and it stems from even way back 2015, 16, 17. Just to share a story. So the company that I work for, Merkle Science, we're an anti-money laundering provider for cryptocurrency businesses. In 2017, when we tried to apply for director's insurance, no insurance company wanted to touch us, despite the fact that we didn't touch crypto. They said they were afraid that we're money laundering. We're an anti-money laundering provider that serves crypto companies, right? But they still refuse to touch us because their perception is you're linked to cryptocurrency in some way. And I think this blanket ban on advertisement may have the same impact of giving people the impression that this is an industry that's not safe, right? Especially it is also coming at a time when the crypto prices are falling, right? A lot of people are losing money. So I can imagine that the fear, uncertainty that's going around is going to be made all the more worse by this advertisement ban, right? So yeah, that's my thoughts.
Osman, your thoughts?
I fully second what Ian says about the unintended consequences, and I think I've highlighted about my own experience with the media company, and I think we've heard now downstream a lot of fintech companies or crypto companies having problems opening bank accounts because banks simply refuse to allow banks to open. And this is where you were talking about earlier on about the mixed messaging, and I think it's imperative upon the regulators themselves to really state a very clear line in terms of, what is it exactly they are trying to police here? Is it AML and KYC, which seems to be the initial thrust of their concerns, and now they move into, trading into, by the retail public, and then by, having this blanket ban. So I mean, it becomes a little bit like mixed messaging to the media, and also obviously to the international world, because they are trying to portray Singapore as a hub for crypto with its very advanced regulation. So something like this with lack of clarity doesn't help that reputation that Singapore has, very carefully cultivated over the years.
I don't know about the real intention that they have, but if you look at the recent, like what Nizam said, at least the last decade and a half, I guess, the regulatory approach that has been taken has been pretty consultative, right? They have been pretty, proactive, objective, outcome focused, and all that, rather than prescriptive. So this comes as a shock in that sense. But I mean, I would like to think that MAS comprises very, very smart people within the building, and which will mean that what we're talking about today is not something that they probably have not thought of, right? Then the question is, why do they need to come to that point to do this now? And I do not know, is it also because, like we said earlier on, at the moment, PSA is the main legislation that regulates this. And unfortunately, it doesn't have that investor protection or product suitability and all those good things that other legislation has at the moment. So perhaps, when crypto and Bitcoin have gotten to the, the highs of the all-time highs, 3-6 months ago, they are probably concerned that, if the prices collapse, then there's going to be a lot of angst within the general public. But unfortunately, there is actually no regulatory protection for these people, right? If really they lost all their life savings, and then, it's going to be pretty bad outcome for the people. So they had to, I think, come up with something quick that doesn't require to go through, a lengthy process of consultation. Again, I'm only guessing, right? That's why it came out like that. But I think longer term, they probably are what Paying alluded to earlier on, the investor protection and some of these other, suitability and all that may well come into the PSA, the regime, which will then make it a lot more, uniform. But the next thing that they could do, or the less worst thing that they could do, is probably to at least publish a more fulsome guidelines on all those things that we talked about and how they interpret, and at least provide much clarity to the industry. The good point that Osman mentioned about the travel rule press release is a good thing for the sector, but you just have people going to the other side of the dial and say, no, I don't want to touch and publish anything to do with crypto, when you do have politicians and whatnot getting into NFTs and saying it's a good thing and all that. I think we don't want to just ignore the elephant in the room, so I thought I brought it up. Then it creates a bit of a very confusing public. What is the outcome that they want? So NFT not regulated, okay, to do whatever you want, and then DPT regulated, then you cannot. Then which is riskier? I mean, it doesn't take a genius to tell you the answer.
Okay, thank you for that. There is a question from Chris Liu. He feels, and there was also another comment, it seems highly unlikely for these guidelines to be removed. So what can we do to ensure that the industry will be consulted before something as disruptive as these guidelines is issued going forward? Okay, my take on this, Chris, is that I think it's important, as part of this process that we intend to make that point across in the set of representations that we're going to make to the MAS. And I think where we can get more credibility in making this point is that if people like yourselves, all your 300 people who are here today, right now, spend 5 minutes, click on the link for the survey and give us your inputs on this. I think that would be a very real feedback that we can use to convince MAS that these are the unintended consequences that these guidelines has, as well as these are some of the issues that needs to be thought about. Okay, so just on that point. So I am going to go to the next set of slides. So what are the issues? So again, I think some of your comments actually reinforce these points. So what is exactly meant by promotion or advertising? I think Ash has made this comment, right? So if he says that a mere call to action to buy crypto now, you have that button incorporated within a third-party app, is it advertising or promotion? He thinks technically it's a call to action rather than giving immediate access to purchase cryptos. So I'm just going to pause here and ask the panel members what they think about this. Any thoughts?
Call to action means act upon it, right?
That's one interpretation, yeah.
So act upon it means open an account and start doing.
So it tends to be, so you're saying it tends to fall within the promotion or advertising then?
I mean, I personally would have thought it is, because usually that's the purpose of having a call to action button, isn't it? Otherwise, why would you even bother? Now, that's why I differentiate that from if it's really a crypto research report that talks about the trends of Bitcoin, for example, and the value of Ethereum, then there shouldn't be any call for action button, I would have thought. Then you can clearly make a decision. Obviously, there's going to be things that falls into the gray zone, and that's why the guideline, the FAQ to the guideline will be pretty helpful, I think.
Yeah, agree.
Okay, we're talking about the lack of consultation. So one other point is that there's no transitional period, right? So remember that for a lot of these newly introduced regulations or laws or guidelines, there will be a transitional period for compliance. So, whether it's 3 months, 6 months, or even in some cases, we have seen 12 months, right? That's not unheard of. But here, the directive was that, okay, you must comply today. And, although it's not specifying the guidelines, there's no specific period for complying. So that seems problematic as well. Okay, I think we have discussed some of these other bits, like no other asset classes and policy inconsistency, going against the disclosure regime. And we've also discussed the need for FAQs. So, okay, here's another question by someone. What would constitute promotional materials? Does it include crypto company being quoted by newspapers or interviews of the CEO, sharing their views on non-company related information? So for instance, on blockchain, and this is then published in newspapers or social media platforms. What are your thoughts? Would that be caught? And should that be caught? Anyone?
I would like to think that it wouldn't be caught, but it really depends also on the actual content that was actually quoted, right? So I think, if what they're talking about is just talking about the technology and the services in a more objective manner, right, then it should be fine. But I agree that, this is something that will take human evaluation, right? You have to take the context into question as well, right? And what's being said and even the platform that is being conducted, right? Obviously, if you're being quoted on a platform that's intended to promote crypto trading, right, then that will become a factor that says, oh, you're actually promoting it. On the other hand, if you're saying the same thing on, let's say, Forbes, right? I think, people might take a different view that, okay, maybe he's just making an objective statement. Yeah, so I don't think it will, nor do I think it should, but remains to be seen.
Okay, here's another question by Ash. Social media platforms, what is meant by this? For instance, would a dating app or transportation or food app fall within this term? Or are they only targeting mainstream social media platforms like Facebook, Twitter, Tumblr, Instagram, etc.? Peng, do you want to, give a view on this? What is meant by social media platforms?
Yeah, that's a good question. I actually just looking at the guidelines, I suppose they refer to social media platforms that target the general public or specific consumer segment in Singapore. So I suppose your guess is as good as mine, and we need some guidance around this, because, for example, if you put your ad on, say, Grab, and you know that it's widely used in Singapore, then that could potentially be viewed by the regulator as going against the spirit of the guidelines.
Okay, thanks for that. Another question, what is the position in respect to sponsorship by DPT providers of events, such as Crypto.com's sponsorship of the FinTech Festival and MES event? Is it not promotion of their services at a public event? So that's a good question. I see Chai Kit smiling, so you might want to comment on this, Chai Kit.
No, I think this is where, yes, a two-page guideline doesn't help, right? Because this is exactly what we're trying to address, the unintended consequences. And I think this potentially will have a huge impact on the MICE sector, events, that has got, whether it's an MES event or not, that's going to be quite funny if that's allowed. But any general events out there, whether is it virtual or in-person event, that putting a sponsorship, a big banner out there, I think technically will be caught. But whether should it be caught, that's a bigger question, and I think it should not. Depending on whether or not it does say things like, buy Bitcoin now, that kind of wording. But if it's just the logo and says nothing else, then arguably that should not result in misleading people to say that actually trading of crypto is low risk. I mean, it can't infer from just have seen Crypto.com's logo, right? If I see Upbit's logo and I see Crypto.com's logo and I see Binance logo alone, what does that actually mean?
I guess the conference part, the argument for conferences is this, right? The whole idea of conference and how they earn, and the whole intent of a conference was to publish to the public. Like, for instance, the exhibitions they have, the booths and all that, right, is to actually showcase and promote and advertise the services of the crypto companies, which includes trading, buying cryptocurrency and all that. The audience cannot be by invite, because then you only have like 10, 20 people in the entire conference at MBS, right? They jolly well can close down. So no one will do a loss-making business, right? So it's actually meant for public, the entire public, invite for people to attend the conference is actually public. Now this comes to a big problem, because all the exhibitors are cryptocurrency company. They are selling their tokens, they are selling the services at the exchange and all that, be it whether they are regulated or non-regulated, that's another question altogether. But that's how they operate. Then when they actually talk on the conference itself or the panel, right, they will be in a certain way selling the products again as well. Some will even be saying, hey, Bitcoin is going to go to 200,000 and all that. The public should be getting in, right? How do you stop speakers from talking about that? This is to the public and it's being advertised, so the public is attending as well. So this is also the same for online webinars as well. So I think this is a very unclear part, and the thing is that, like, people like Token 2049, I've spoken to them, right? They are even having a very warped idea about this entire thing. Say, oh, this MES guideline doesn't affect us. First, we are from overseas. Second of all, I understand that only scam coins are not allowed to advertise. So all other can advertise. We don't care. I think the Singapore law doesn't apply to them. So, that kind of thinking coming from people as well. So this is going to be very nebulous, because once you have people who understand, they will not come to Singapore. Now, people who misunderstand comes to Singapore, get stopped on the first day of the conference, lose a lot of money. It's going to generate more ill will to the media as well, for conferences to be shut down on the first day. So this is going to be a major concern. Yeah.
Okay, someone has a question on influencers having referral links which they promote. Would that count? Any thoughts on that? Again, we don't pretend to know all the answers, but we're just getting some views from the panel members. Anybody would like to take a stab at that? Ian, do you want to take a stab at that?
In my opinion, I don't think it would be caught. However, it's different if, let's say, the DPT service provider is paying their influencer to put their referral, or giving them, better rate than, let's say, a general referral program, right? But if, they make that referral link available to everybody, and, anybody can then share it on their own social media and there's no added incentive, I don't think it will be caught. But I will caveat that's my personal opinion.
Of course.
I also wonder the question about if you refer one person versus you refer 1,000, would that make a difference?
I think it does. That's why the use of like the example that you mentioned, if you're using an influencer, because an influencer has got 1 million, followers, and then using him or her to, publicize that, obviously will be using a third party, right? So that would be caught. But if you're using a one-to-one referral program, like I mentioned earlier on, like a lot of brokers are doing it today, the capital markets brokers are doing it, then it, in my opinion, it should not be caught. Whether it will or not, it's not up to me to say, but it should not be, because you're not really marketing to the public, but you're, it's through a one-to-one basis.
Okay, let's move on to the next couple of slides here. We only have a few more slides to go through. Okay, I think a lot has been discussed about the UK approach, and we think that the MAS definitely had, or presumably had looked at this when they decided to issue their own advertising guidelines. Now, in the UK, I think importantly, there wasn't, as far as we know, there's no blanket ban on advertising, but the focus is that promotions and advertising must be clear and not misleading, and it must be done by approved persons, in other words, regulated persons. Importantly, there was a public consultation and a transition period that was specified, which was unfortunately not the case here. So just to move on as well, sorry. So this is taken from the UK FCA graphics on high-risk investments. So this is actually very interesting, because if you look at crypto assets, right, they are allowed, so mass marketing allowed to retail investors subject to certain restrictions. So that's interesting. Non-mass market investments, and these would be certain specified products like illiquid securities, for example, speculative mini bonds. So mass marketing is banned to retail investors. So the UK position is, first of all, there's no ban on advertising for cryptos, even if there are some mass marketing bans on speculative illiquid securities, for instance, speculative mini bonds. Now, this is quite different from what we see in Singapore. So I'm just going to pause here. Any thoughts on this? Paying, maybe you can share with us your insights on this.
Yeah, thanks, Nizam. So I suppose, as we briefly discussed just now, the fact that there's no blanket ban in the UK is useful, and the UK regulators have given a 6-month transitional period from when the legislation is finalized to when it will actually take effect. So there's at least time for people to react. And also they have carved out certain things. So they carved out e-money, they carved out CBDCs, and they also are consulting on this approach. And I think Spain is taking a similar approach as well. So Spain, for example, would say that companies that market crypto assets, they have to inform their regulator at least 10 days in advance if their content targets more than 100,000 people. So at least there's still an approach of not having a blanket ban. I suppose the question is, is the UK approach perfect? Is it all a bed of roses? So not entirely. There's still some issues to work through. So for example, in the UK, there's a concern that there may not be enough sufficiently qualified approvers, because what the UK regulator is saying is that you need your advertisement to be approved by a sufficiently authorized approval. So I guess the question is, do we have enough of these people in the UK? And there are also minimum conditions to be met. So firms registered with the FCA for AML purposes, for example, will not qualify. So we think the industry may struggle initially. And then I suppose the second thing also is that, like Singapore, it's not very clear whether they have extraterritorial effect. So the regulator has said that the rules will apply to any kind of in-scope promotion capable of having an effect in the UK. So I think that's still a bit of a question mark that needs to be clarified. So having said that, though, we do think that just having a consultation and giving the industry a chance to comment is immensely useful.
Thanks very much for that.
Then I would second that, Pei, in terms of your views, the fact that I think it's something that we should also be advocating the MAS to walk down that path towards a more balanced approach in terms of what is and what is not allowed, because I think there is at least some clarity there in terms of what is in scope with the UK's approach versus the current one that MAS has. So if anything, I would definitely second the fact that it's something that we should push that the MAS to take a look at the UK's approach.
Okay, thanks guys. Let's move on to the next slide. And actually this is a poll question for the audience. So we still have 247 people still with us. Can we run the poll, Kevin? You're on mute, Kevin.
Okay, yes, the poll is
So
up.
what do you think of the UK approach? Makes more sense, Singapore should adopt it. Second option, Singapore's approach is better. Third one, UK approach is still restrictive. So which response resonates with you? Let us know.
Okay.
Okay, are we about to be done?
Yep. 5, 4, 3, 2, 1. Okay, I think some more. Okay, we'll just stop here. Okay. So you can get majorities, almost 70% thinks that it makes sense.
70% and 23% still think that the UK approach is still restrictive. So that's interesting. Only 9% think that Singapore's approach is better. Okay, that's really cool. Any of the members of the panel would like to make a comment on that? Chaikit, your thoughts?
I do not know if it's good to compare which is better, because I suppose different regulators have got different objectives and different markets and the sophistication of the general public to deal with, right? And so, but I think the key point here is that it's not so much of whether it makes more sense that therefore Singapore should adopt it, because there's no way Singapore can adopt it now that the thing is already out there. What we can possibly seek to achieve is what additional clarification on the regulatory intent, and a bit more guidance can be provided to soften the implication. The mines issue that was talked about is major, right? And is that something that they want to see? For example, right? Maybe it's an unintended consequence, which then with clarity on the FAQ or the guideline, then we can move towards a more middle ground. Because we can't go back and say, hey, last order cancel and let's redo this, right? I wouldn't have thought that's something that is ever on their mind.
Well, they
don't
could
be
come
so
up with some
fatalistic.
They could have some amendments to the PSA, right, to cover some of the investor protection, and therefore.
Oh yes, of course, that will eventually come, but I think that's something that will take a longer time to get to. But if you're talking about the effects of this guideline that has been issued and enforced, although there's no force of law, it's already there, right? So people need to figure out what to do with it, right? And then a much needed FAQ will help people get through that process sensibly.
Yeah. Okay.
All right, thanks. Let's move on to the next slide. And I think we are probably gonna go into the capital markets. I think we have broadly discussed this. That under the Securities and Futures Act, there are all these prescriptions on advertising, disclosures, product client suitability, the selling process, enhanced regime for higher risk products, etc. And I think we discussed this, so we're not going to go through this now. So let me just move on. So I suggest let's not do this poll, even though we planned for this. But I would like to discuss this in the context of the many questions that we're getting at. So there are many scenarios which might not be too evident as to how the guidelines would treat them. So for instance, if you have some marketing done at the group level, you obviously belong to a broader international corporate grouping. And there's advertising being done using third parties. So to what extent is Singapore impacted? I think we talk more about whether the effects doctrine would apply to Singapore. And then the relevance of crypto debit cards. So here it's a little bit different, right? Because the service being provided is that if you have a crypto, you can use the crypto to pay for goods and services on your debit card. Slightly different risks from crypto trading, where you're offering a service of buying or selling cryptocurrencies. And then there could be another scenario where a crypto exchange wants to announce a tie-up, or you get a funding round, Series C or D. Can you do that? If you run education or seminars or events, I think there's quite a few questions on that. Sponsorships, like sponsorship for the Singapore FinTech Festival. So is there a need to articulate a link to Singapore, the effects doctrine, as we discussed? So if somebody wants to do events for non-retail but accredited or institutional investors, even though there is no such regime under the PSA, but is there leeway for that? And then if you were to want to do training, whether in conjunction with the Institute of Banking and Finance, or even running a money sense program, which is administered by the MES, is that allowed? How about people selling mining machines? So these are not cryptos, but they are linked to cryptos, obviously. Is that allowed? Or distributing t-shirts or umbrellas with corporate logos. Merchants accepting cryptos for payments, and you have a little sign there to say that this is I'm a payment platform. You can actually pay using cryptos here. So does that constitute advertising? So we don't know what the answers to these questions would be. We probably have a view on this, but I'm going to throw it to the panel. Should we get more clarity on these scenarios, or sometimes is ignorance better than having more prescription? So what do you guys think?
I was about to say this, Nizam. I think be careful what we wish for, because if we, in a lot of cases, I think as I mentioned earlier on, the regulatory evolution process would mean that regulators around the world, or the more advanced regulators around the world, are trying to move away from being overly prescriptive, which allows for some room for to maneuver, for the industry players. Now, if you want absolute clarity, then you are asking for a very prescriptive set of do's and don'ts, which on one hand, it makes it easier because it's clearer, but on the other hand, it ties you down because you just do as you're told, or you don't do as you're not told. So I think the industry got to figure out which actually works for now. Now, these scenarios are what I think we came up with, and thanks to Nizam for putting this together. But I think by and large, these are the more pertinent ones and the more obvious ones. There's obviously not going to be an exhaustive list of scenarios that they can cover, and which is why the suggestion of an FAQ, because this is how they normally do it, right? With a notice that comes with a circular, and then it comes with the FAQ. Now, then you can even argue that, even if they prescribe it in the FAQ and things that is not really covered and not explained, again, if a circular hasn't got a force of law, then an FAQ is just a reference, a best practice guide at best, yeah? And then you do give yourself some room to maneuver. But absolute clarity means that it's prescription, which I do not know whether it works for everybody.
Azman, your thoughts as a crypto exchange?
Yeah, I think I agree with Chai-Kit that we do not want to see something that's overly prescriptive, but nevertheless, we do like some details and a little bit of clarity, perhaps. Maybe that's one for a word. But I think a more principle based on some sort of a balanced approach, like what I suggested earlier, that to look at the UK model seems to me like a better model for us to suggest to MES. It might take some time for them to implement, to take into account all of the regulations that is already in place here in Singapore. But I think in the long term, that will probably be something that I would like to see here in Singapore as well, because then it will obviously allow us to basically maneuver and operate in a more proper fashion. And don't forget, a lot of the times, we are relying on investment coming in, and if you want to stimulate the growth in the ecosystem, some of this clarity is important, and we need to have some sort of a more balanced approach towards this kind of activities. So I think those are my thoughts.
I think that let's run the poll, Kevin. I think we have to skip one poll just now. Maybe we will get a sense from the audience. What do they think? Should we get more clarity on these scenarios? No, the next one. Yeah, so, we need to skip this. Okay, so this actually, sorry, I probably misunderstood this. So let's run it anyway. So the last poll is, what do people think about the MES guidelines? Is it overly strict? So ignore just right. Second is just right, and the third option is not strict enough. What do people think about this? In the meantime, there's some of these comments that we have gotten. For instance, referral programs, whether issuing a press release would be caught. I think it's likely to be caught. So we will take these as some of the areas for clarity, because I don't think we can answer a lot of these questions, because we don't know what the intent is. I mean, that's the honest response. Okay, so coming back to the poll questions, I think mirrors the last one, that 73% of people think that it's overly strict. 19% of people think it's just right. Interesting. And 8% of the people think they're not strict enough.
Not strict enough.
I wonder who is that 8%.
Exactly.
Okay.
I'm curious.
Actually, who want to stay anonymous?
Oh, come on, we have to welcome, we have to, respect people's views on this. Yeah. So just let us know which bank you come from. Just kidding.
Can I make two comments, Nizam, very quickly on the scenario thing? And I think there is really an opportunity here for blockchain associations of Singapore, for example, to really try and educate people, right? Work with IBF or MoneySense or whoever, or with tertiary institutions to try and drive the concept of education, and then that can also demonstrate over time to the MAS or the regulators at large that the effort is coming up from the community, and we are trying to do the right thing, as opposed to we're just trying to make off quick money and try and scam people of crypto trading. That's one point. So going forward, there should be more educational focused stuff, I hope, coming out from associations like this. And another one is, there's a comment or the questions around, do you recommend compliance, approve, or publicity for now? I think that's probably something that internally within your organization you can consider, because in light of all these so-called new guidelines and restrictions, then regardless, someone internally to review it before it goes out is not a bad idea, and I think it occurs in the current traditional finance space as well, right? Be it FA, broker dealer, or even the banks.
Yeah, there was a suggestion that BAS should draft the FAQs and send it to the MES, but okay, I'm not sure whether the regulators will be open to this. I think hypothetically, if advertising was still allowed, BAS as an industry association can certainly publish a set of best practices on advertising or promotions or running events. But if you don't allow the advertising, I think it might restrict on what BAS can do, right? Because it's non-starter to begin with.
It cannot be from, I don't know, I just don't think it should be from BAS. BAS can suggest these are scenarios, questions that need an answer, And the answers have to be coming from MAS, because that would show or demonstrate the regulatory intent, for each of these scenarios.
Yep. So there's a question on whether the slides will be made available to participants. The answer is yes. If you request for it, just drop us an email. So yeah, I think the other bits are all points that we can consider as the part of the scenarios that need to be put across to the MES. Any of the panel members have any other further thoughts?
For me, just one, in terms of, looking at we are trying to here speculate over the intent, the real intent and objective of some of these regulation and guidelines. And I'm wondering whether there's any maybe argument to be made, whether there's actually a real concern about the growth and adoption in cryptos because of the relative, obviously, impact upon, the current markets and the current asset classes, and also the other thing. And it's just a question that I put out there, and it's obviously, I have my views, but it's I think it's worth considering whether indeed there's some, intent that they want to slow down a little bit about the growth and adoption of the crypto industry as well.
Yeah, thanks for that. Again, so this is not the end of the conversation, right? So please let us have your thoughts on the link that have been circulated to you all by email. That is very, very important for us. So we want to get as much inputs from the industry as possible. I think we've run quite a bit of time, almost 2 hours on this webinar, and thank you to the 225 people who are still with us today. I think your points are very important for us. But let's keep the engagement open, and hopefully we'll also get a receptive response when we present the representations to MES. With that, please join me in thanking the panel members, and I'll hand you back to Kevin.
Thanks for sharing, everyone, and thanks for. Do we want to finish the questions, because I think we got still a bit of questions there, or how do we want to proceed? We answer the questions?
Honestly, I don't think we can answer a lot of these questions on whether these fall within the guidelines or not.
Do you want to have a quick look through to see some relevant ones? I think just probably answer 1 or 2 more, just for the sake. Well, I actually shared the link to the survey. Yep. So
influencer, YouTuber in Singapore promoting crypto to the world and not just Singapore viewers. Does it fall within the prohibited activities? Anybody wants to take that? Paying? You want to take a stab at it?
You're looking at the chat, or you're looking at the Q&A?
Q&A.
Q&A.
Okay, sorry.
Yeah, I mean, that's a good question. I think that was the point that I briefly mentioned just now, that at the moment, it seems quite broad and doesn't have any kind of clear Singapore nexus. So the question may be, well, is that person is based in Singapore? Perhaps if you look at that person's subscribers, are they mostly Singaporeans because that person is in Singapore? If so, then it's possible the MES may say you are targeting your services in Singapore. Yeah.
Yeah. So probably a darker shade of gray. Yeah. Okay, that's fine. Phone text messages consider advertising. I think it does. I don't know whether the panel members would agree or disagree on that.
Without clickable links, otherwise it borderline scams.
Well, I suppose, okay, let's make it more granular, right? So if I have phone text messages to my existing group of customers,
yeah, probably okay.
But if
no, like I said, existing customer not a problem, right? But if it's to other people, then yes, that might be problematic.
Okay, that's that. Press releases. I think press releases probably would be caught because the intention is for a media to pick it up. Anybody thinks otherwise? Okay, that's that.
Yeah.
It depends on what is it that you're releasing on, right? Like you said earlier on, I think if you're releasing on, let's say, for example, mergers, acquisitions, and corporate actions and stuff like that, that, or you have discovered a new chain, for example, a new technology, blah, 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 then those probably wouldn't be caught.
Well, except the guidelines did make a reference that even if it's non-product specific, but you're promoting your company, it could be caught. So it's a little bit vague, I think. But again, I think that's an issue that we can probably get clarity on.
Yeah.
Okay, another one. Do the guidelines change how non-Singapore VASPs that do not want to target the market in Singapore should do their advertising? So if you're non-Singapore VASP and you don't target Singapore residents, then I don't know, shouldn't apply to you to begin with. Anybody has a contrary view?
If you're a non-Singapore VASP, then you are not going to be under the DPT, license under PSA or exempt, right? So that obviously is not relevant.
Okay.
Yes, this is a real question, is because there's a lot of projects that couldn't do in their countries, like in China, in Korea, in Japan, and all that, right? And then anywhere else, right? They're all coming to Singapore and incorporate, so that it's a legal entity. They is under certain law, right? Then they sell back in their own countries. No, obviously not China, but in Korea, in Japan, and all that. So I think this is the case because the omnibus law is coming out, and that mentioned about the extra jurisdiction powers of MAS with regards to financial services. So that could potentially impact this eventually.
Yeah, akan datang lah, wait until that comes out, then we talk.
Okay.
But the question was on non-Singapore VASP. So if you're not incorporated in Singapore and you don't target Singaporeans, I think it's generally Singapore law shouldn't apply.
Yeah.
Okay. Okay, another variant, exchange applicant where the exchange is situated in a foreign country, markets to foreign users, but the management is located in Singapore. Is that caught? Any take on that? I think that's an omnibus. Okay, not very clear whether it's an omnibus act because it's just a management physically here, but presumably the legal entity is outside of Singapore. So it looks like it might not be unless somebody has a different view.
No, it depends on if your markets to foreign entities, that means you're not targeting the general public in Singapore. That's the scope, right? Then you will be out of scope.
Yeah, I agree. I suppose the question is, if you have management located in Singapore, there may be other issues you need to think about. Like, does it mean you need to actually set up an entity here because of what you're doing from Singapore? But that's a separate question to the promotion guidelines.
Yep, agree with that. Okay, I would like to hear your views on the case that even though there's a blanket ban on advertising, there is no way of preventing overseas advertising from social media and use of VPN. That seems to be more of an enforcement issue. Right.
But
so
it would also be unfairly prejudicial to the local VSP players as well, because clearly an overseas exchange.
Agree. Then you know what you can do is to basically
do the same, is it?
No, you can just put their names to the enforcement department.
Well, there is a no solicitation prohibition in the Payment Services Act. I guess the question is perhaps one of enforcement. How are you going to enforce it?
Yeah, I think it's just not just specific to payments, right? It could be across any of the other products, right? So there will be sort of issues, and sometimes
which is
shades of
sorry,
gray, yeah, because
which is why you will go into the investor alert list.
But because this is also the nature of the business, given the fact that it's purely online, and some has some, a little bit more, you have to deliver goods physically or something. Well, this is obviously everything is conducted online. So the ease of transaction is a lot, less. For me, if you want to transact using Binance in Singapore internationally, there's very little difference except through VPN, right? But the nature, the product is still the same. So from a retail perspective, they're getting the same point, but I think it's just unfairly targeting the local players. That I think is more the issue.
Yep, I hear you, Osman. Yeah.
Thank you for understanding my pain.
Ash is being cheeky. He says, what would constitute a social media influencer? Would a powerful CEO of an automobile or tech company be one of them. Or if I get Nizam to promote for me, you will not get very much headway when Nizam does that. Would it be an influencer?
Yes.
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 Lon was dragged in by the SEC, remember, for some of his comments. So,
Okay. Done. Second, come on, Lehman Junk bonds. I'm not sure what the question is, so we'll just skip this. How should we go about developing a proposed education approach that is effective in addressing the concerns of the regulators while meeting the business objectives of the DPT-centric business? And that's an interesting point. Anybody wants to take a stab at it?
hopefully through the industry, like BAS and all, that we have to now, educate. But I think it's also, we need to get clarity from MAS what is and not allowed in terms of events, seminars. So I think following that, I think there's some follow-up action that we can do as an industry body.
Okay, that's fine. Moving on to Ash again. Specific consumer segment again. What is specific consumer segment? How is segment versus specific? What's the difference? Who is a who is a consumer? A paying customer or people who consume something? Would an advertisement in a bar fall under this? Sounds like it.
I don't think we're using the word consumer. It's probably retail, right? Retail public. I think that's the term that we should be focused on.
Okay. Advertising in a bar, would this fall? I think it's one of those gray things.
Advertise what?
Let's say you advertise your crypto exchange in a bar in Boat Key. Would that be caught under the advertising? Question is
right. It will be
area. Yeah.
It will be a public area to a third party, and if you are paying, the bar for the space or putting out the advertisement, it's the same way as you put the advertisement on the taxi and buses, right?
Yeah, arguably. I don't know what the answer is, but it can be something that we can ask the MAS. So there was a suggestion MAS should not ban crypto advertisements. There should be a disclaimer notice that crypto investment is a high risk. Yeah, I think that's sensible. And I think that's.
But we're past that.
Sorry, go ahead, Chaikin.
No, I said we are past that point, that whether it should or should not, it's already there. So now the question is that how do you cushion the effect? Obviously, disclaimer is required, but if the
I think the point of view is that, I don't think we should take a stance that everything is cooked and we're just here to add in, side dishes or, to the dish that's being cooked. I think it's important for the industry to make representations that that's my feeling, and I think we can discuss it internally.
Of course, we should have that.
Yeah, if the dish is already cooked, then what can we do to cushion the impact, as you rightly pointed out? But I think the starting point should still be some form of a set of representations to push back on this.
Yeah.
To suggest that it's overcooked. The first is
yes. But to Peng's point earlier on, right, the disclaimer itself sometimes, it's not that you put a 20-page disclaimer out there, then you are covering yourself for the purpose of getting to the right outcome, that general public doesn't get misled, because we know that it doesn't, right? That's why in the investment space you have product highlight sheets and all these things to try and distill things outside of all the very legal disclaimer to protect the issuer or the banks.
Yes, absolutely. Okay, next question from Sugandhi. Guidelines talk about general public, high net worth individuals or accredited investors caught in the definition. Well, there is no concept of AIs under the PSA, but so I think the question is, if it's not really a retail, but it's a select group of high net worth individuals, is that permissible? Any takers on this? I don't know what the answer is.
I think it will be defendable to say that, if you are only marketing it to a group of accredited investors, but by that would mean that you would have assessed them and they are accredited investors that are already your customer, right? So I don't think they will be caught under your marketing to general public per se. because you must have gone through that to confirm that they are accredited investor. Maybe you are already selling them other products, and therefore the crypto side is just an add-on activity that you do.
Okay, I think it's worth asking these questions. It's not really the vulnerable. I think the message is not really the vulnerable community. So even if there isn't a formal adoption of the accredited investor regime, but going back on first principles, these are not likely to be your vulnerable communities. Can we do it? So I think it's worth asking. Next question. Okay, this is more a comment than a question. MES has stated that crypto is not for general public. Yet today we read the news that Temasek has invested in FTX. Isn't the message still a bit confusing? Okay,
Temasek is not general public.
That's true. And Temasek is also from MES.
Yeah.
So yeah.
Would you consider them as expert or institutional?
Institutional. Yeah.
But they're not regulated, so they can't be institutional. So they are actually AIs.
AIs or expert? If you downgrade them to AI, I don't think the Temasek board will be very happy. Sorry.
We don't want to offend the Temasek board, do we? Okay, let's move on. What's the view? So we actually talk about referral programs, so that's done. On BAS's role, I believe he has a role to do public good over the use of blockchain in a broader context. There are many excellent use cases of using blockchain as token for payments of ownership. We should drive to not only educating the public about blockchain more than just cryptos, in addition to creating an ecosystem that drives efficiency and transparency. So these attributes potentially establish more confidence and trust in a society. Thank you. I think that's an excellent suggestion. I think we're already doing it to some extent, Kevin, and maybe we can do more.
Yeah, I think we are doing that to a certain extent. And then with this public kind of participation, right? This is just part of public service. I think we should be expanding more, beyond blockchain, which is why, we did the first NFT charity option, the event with NTUC and then Straits Times, right? This is also to show that crypto is not all about greed. It can be for good as well. So I think, or rather, NFTs, right? So yeah, definitely there's something that BAS is trying to push towards.
Okay, next question. What if a foreign project incorporate in Singapore and do not offer services to Singapore retail, banning IP or have a whitelist system?
That's the one I raised out. A lot of Korean, Japanese companies are doing that right now. And I think as of now, if they don't solicit it in Singapore, then I guess not. But like you were saying, right, when the omnibus law akan datang comes, right, that's it.
Yes, you've just summarized the response to that, so that's done.
Yeah.
If a company spokesperson is participating in, say, a third-party education YouTube live stream on industry topics, could a short corporate intro be given? Will this fall within promotion and advertising? Good question. Any take by the panel members? Ian?
Yes, what is stated, right? What is it being represented? If it's only factual, then perhaps it's not considered promoting or marketing. But I mean,
I agree.
Beyond that, depends on the language.
Yeah. Again, I think it's probably good to get a safe harbor clarity from MES on this. That's my thoughts. Okay. There are no statutory protections for customers under the PSA for DPT, except for the provision of a risk warning, PSN08. Do you think there will be protection added now? Chaikit, you mentioned this just now. I think you think yes.
I think, it takes a few steps to nirvana. So I think, again, be careful what we wish for, because this actually puts on more compliance costs on the licensee. Because you need to administer the whole regime of assessing the suitability and blah, 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 and it becomes fairly painful.
Yeah, it does, but I think it's hard to avoid it, because in truth,
agree.
Yeah, there is
it's hard to avoid it.
That's the reason why people buy cryptos, right? There's an investment element to it, and with that comes across, the risks are very similar to other capital markets products. Yeah, but correct. I think that the key is having a consultative process with the industry to see what makes sense and what doesn't make sense. I think that's quite key. And finally, the last comment is thanks, to which our response is you're very much welcome, and thanks for being with us for the last 2 hours. I think we need to wrap it up right now. We are already approaching 5 p.m.
Yep. Thanks everyone, and that is really a good closing. Thanks for saying thanks. So, yeah, I think we will this recorded. I think we'll be sharing some of this information out, especially the result of the survey and also some of the slides as well. So take note of that. Follow us on our website or follow us on our social media. You'll be giving out the link to where you can see all this as well. So, yeah, thanks everyone for participating.
Okay, Kevin, please don't forget to remind them about the submission of the feedback and onto the questionnaire.
I was about to come to that. So
the link where they can get it.
So the link is ready on the link is ready on the chat group. So just now I share, maybe I share another time as well. So feel free to quickly do the so-called enter in the survey. This will actually close on Sunday night. We will compile that, give you a few days to actually share with your friends, who are in this space. Give your honest feedback on that. It will be compiled. We'll share the results out before we will share this with MAS. Yep.
There's a suggestion of a Telegram group, so Kevin, maybe something a BS can consider as well.
Yeah, definitely. Because now I think everybody use Telegram. I don't know everyone pushing me from WhatsApp to Telegram, which I refuse to. But anyway, yeah, we'll do the Telegram. Yeah.
Okay, fantastic. Stay safe, everybody.
Thank you.
Thank you.
Bye. Take care.
Happy New Year to everyone. Bye.